Ayan. So here under Article 1545, dun sa first sentence, you can already see that there's an obligation arising from a contract of sale. Okay? And this obligation daw is subject to any condition, and this condition is not performed. Okay? Ano daw mangyayari? Such party may refuse to proceed with the contract, or he may waive the performance of the condition. So, under the first sentence of Article 1545, we're talking about a condition. Okay, we're talking about a condition. Meaning that in a contract of sale, wherein there is an obligation that is subjected to a condition wherein it is not performed, there are two remedies of that party, of either party, whether to refuse to proceed with the contract. Of course, if it is not performed, you can refuse or waive. Paano? Let's put it in an example so that we can understand it clearly. Okay? Let's say, for example, I will sell to you a motor vehicle with a discount of 500,000 pesos. So, discounted. Okay? If you pass the CPA board exam. Okay? So, this one, the last part is your condition. If you pass the board exam. So, there's an obligation or there's an obligation in the contract of sale na meron kang discount if you pass the board exam. Okay? Ang sabi dito ni first sentence, if it is not performed, ibig sabihin, if, for example, in the future, okay, let's say, for example, si Mr. A did not pass the CPA board exam, okay, the seller may refuse to proceed with the contract. Of course, naturally, hindi nga nagawa yung condition, di ba? So, I can refuse to go with the contract. Hindi mo naman napasa yung board exam. So, wala kang 500,000 peso discount. Pwede mong bilhin, pero at the original price. Okay, walang discount. Okay? Or, sabi ni first sentence, he may waive the performance of the condition. Paano kapag winave? Kapag winave mo daw yung performance ng condition, ibig sabihin, whether magawa yung condition, whether pumasa ka sa board exam or hindi, I will offer you a 500,000 discount. That is the first sentence of Article 1545. So, in this case, if there is a condition in an obligation in the contract of sale, and that obligation has a condition before it may be enforceable, okay, and then it is not subsequently performed, either party may either refuse to proceed with the contract precisely because the condition has not been performed, or second, waive the performance of the condition and proceed with the obligation. Okay, so parang wala nang condition. Parang naging absolute yung sale. Okay? Second sentence naman, if the other party has promised that the condition, meaning, a same scenario, there's a contract of sale, wherein there's an obligation, there's a condition that is subject, the obligation is subject to a condition wherein this condition was promised na mangyayari, should happen, or be performed, nagagawin. So may parang guarantee ka. Such first mentioned party may also treat the non-performance kapag hindi na performing condition that is equal to breach of warranty. So this is the second sentence, meaning this talks about warranty. Okay? The first sentence talks about condition. Okay? If there is a contract of sale, mayroong condition, that condition is subjected, that obligation is subjected to a condition, ayun, yung 1545 first sentence. Pero yung second sentence talks about warranty. Okay? There's a contract of sale wherein the obligation is subjected to a condition wherein the other party has promised its performance or he promised that it will happen. Its non-performance will be a breach of warranty. Okay, take note ang difference ng condition dun sa warranty is yung merong promise. Okay? Sa warranty kasi, you are promising or you are guaranteeing that you're guaranteeing something of the product. Okay? That's why its non-performance is tantamount to breach of warranty. Okay? Hindi siya yung kagaya ng first sentence na meron kang remedy to refuse or to waive. Dito, there is already a breach of warranty and the other party at fault will be liable for damages. Okay? The second paragraph, where the ownership of the thing has not passed, the buyer may treat the fulfillment by the seller of his obligation to deliver the same as described and as warranted expressly or by implication in the contract of sale as a condition of the obligation of the buyer to perform his promise to accept and pay for the thing. Ano ang sinasabi ni second paragraph? Sabi ni second paragraph, okay, if the seller delivers the thing to the buyer, okay, the buyer daw may treat such delivery as a condition. Condition for what? Condition for the buyer to pay and accept the thing, of course. Diba? Babalik tayo sa earlier stages ng sale natin na topic. Diba? Sabi natin, this is a sale is a mutual contract. Okay? Wherein both parties have obligations as to each other. Okay? So ito na yun. You can best describe it here. Okay? Wherein the delivery of the seller of the thing may be considered by the buyer as a condition for him to pay and accept the thing. Okay? So that is the second paragraph of Article 1545. So, since we are already discussing about yung first sentence, which is the condition, and then the second sentence, which is a warranty, it's high time for us to distinguish a condition versus a warranty. Okay? A warranty, the first difference, warranty is wherein a performance of such obligation may constitute an obligation in itself. Okay? May constitute an obligation in itself. While for a condition, it is the root of the existence of the obligation. Diba? Itong nasa condition, itong first difference, you can see it here dun sa first sentence ng Article 1545. Okay? Na, let's say for example, ibahin natin yung example. If A will marry B, then I will give you my my car. Okay? If A will marry B, I will give you my car. Okay? Meaning that if later on A marries B, okay, na fulfill yung condition, okay, then there exists an obligation. Diba? Nag-exist yung obligation. It is the root of the existence of the obligation. Pero kung hindi na-perform, ibig sabihin, A did not marry B or A married another person, okay, then there is no obligation created. Okay? Unlike dito sa warranty, a performance of such obligation may constitute an obligation in itself. Why? Because there is a promise. Diba? Sabi ko kanina, the difference between condition and warranty. Diba? Sa condition, you cannot control or you cannot promise it. Diba? Kasi nga, it may or it may not happen. Dito naman sa warranty, you promise that that condition will happen. Okay? So, the promise in itself is an obligation. And then, kapag nagawa yung obligation na yun, there will arise another obligation. Okay? Kaya nga, kapag hindi nagawa yung first condition, which is the promise, it will become a breach of warranty. There will be a breach of warranty. Okay? In warranty, the second difference, it may form part of the obligation or contract or provision of the law without having agreed thereto. Meaning, ang warranty daw ay may dalawang klase. Meron tayong express warranty, meron tayong implied warranty. Okay, when we say express warranty, it is stipulated in the contract. Diba? It is part of the contract or obligation. Nandun nakalagay sa contract of sale, may stipulation na I am warrantying or I hereby warrant that this property belongs to my name. Ganyan. Inawarrant mo na sa'yo yan. Ibig sabihin, kapag let's say for example, stick na tayo dun since nabigay ko na example yun. Binawarrant mo na the property is yours. Meaning, kapag binenta mo yan, let's say for example kay buyer, and later on si buyer habang nasa kanya na yung property, merong lumapit na stranger or na tao at sabi, hindi, sa akin yan. Kinuha yung property in a legal way. Okay? Na-oust si buyer of his possession and ownership. Liable ka na nagbenta. Yun yung warranty. That's why we say kanina, the performance of the obligation is an obligation in itself. Okay, express warranty. Okay, while here, implied warranty, kahit walang nakalagay sa contract. Kahit walang nakalagay sa contract na yan, meron kang warranty. Okay, this one we will discuss later because this warranty is provided for by law. Okay, implied warranty. In condition, di ba yung sabi ko kanina sa warranty, it may be express, it may be implied. Okay, pwedeng nasa contract, pwedeng wala sa contract. Dito sa condition, dapat nasa contract. Must be stipulated in the contract. Okay, kapag walang condition, the sale is absolute. There's no condition. Okay? Non-fulfillment of a warranty would constitute a breach of warranty or a breach of contract. Okay? Sinabi mong ganyan, this is a cause of action or pwede ka mag-file ng case against a person or someone. Okay? Sa condition naman, it may extinguish obligation upon which it is based but does not generally amount to breach of contract. Okay? Kapag hindi nagawa yung condition, generally, walang obligation. Diba? Lalo na kung yung condition, lalo na kung yung obligation is subject to the condition. Meaning, Mag-a-arise lang yung obligation mo kung mangyari yung condition. Yun. Kung hindi mangyari yung condition, extinguish. Hindi siya automatic na breach of contract. Unlike sa warranty, sa warranty, kapag hindi nangyari, okay, non-performance is already a breach of contract in itself. Automatic. Okay, unlike in a condition, hindi. Okay? It may just give rise to the obligation or it may extinguish the obligation. That's the difference between a warranty and a condition. Okay? There are two types of condition imposed on the perfection of the contract and condition imposed on the performance of an obligation. Kapag it is imposed on the perfection of the contract, meaning it prevents the juridical relation from coming into existence, meaning it may give rise or extinguish the obligation. Diba? Ganyan yung perfection of a contract. Dito kasi sa condition imposed on the performance of an obligation, there is already an obligation. Okay? That's why the party or the other party may either refuse or waive with the contract. Parang although it is imposed on an obligation, you can either continue or waive the condition. Yan yung condition, two types of condition that is imposed on the perfection and the performance of the obligation. 1546 talks about express warranty. Okay? We have discussed earlier that warranty may be express or may be implied. So we'll talk about express warranty first. Okay? An express warranty is an affirmation of fact. Diba? Ibig sabihin, quality yan. Maganda ang quality niyan. Diba? Mabilis yung processing niyan. Maganda yung technology. Yan, affirmation of fact. Or any promise by the seller. Okay? Sir, garantisado yan. Hindi yan kagad masisira. Tatagal yan ng 5 taon. Okay? By the seller relating to this thing is an express warranty. Provided, take note hindi lang siya basta affirmation or promise. Okay? Dapat this affirmation or promise must induce the buyer. Must induce the buyer and that the buyer must have relied thereon. Okay? So, what is an express warranty? An express warranty is an affirmation of fact or a promise by the seller wherein the buyer was induced and later on relied on the on such affirmation or promise. Kumbaga parang nakuha mo yung tiwala ng buyer. That is an express warranty. Without that express warranty, hindi bibilihin sana ni buyer yung product. Diba? Pero sinale stock mo di ba? Magaling nga mga salesperson, di ba? Magaling magsalita. Sinale stock mo na-induce tuloy si buyer. Tapos nag-rely siya dun sa sinabi mo. Kaya niya binili. That is an express warranty. Okay? Then to the second sentence, no affirmation of the value of the thing, nor any statement purporting to be a statement of the seller's opinion, only shall be construed as warranty. Meaning, if it is about affirmation of the value or mere seller's opinion, sabi ng batas, guys, it is not an express warranty. Hindi siya express warranty. Why? Affirmation of the value. Sir, this is worth 10,000 pesos. Ma'am, this is worth 50,000 pesos. Wala ka namang ginarantee. Wala ka namang in-affirm na fact about that product or that goods. Diba? Ang in-affirm mo lang is the value. Yes, ma'am, this is worth 10,000 pesos. Nothing more, nothing less. That is not an express warranty. Okay? While if it's a mere seller's opinion, okay, a mere seller's opinion. Sir, sa pagkakaalam ko kasi ganito, maganda yan, ganito, ganyan. Okay? Based sa personal ko na opinion, sir, nung nagamit ko yan, ginagamit ko kasi yan sa bahay, maganda siya. Okay, effective siya, ginagawa niya yung ganito, ganyan. That is merely a seller's opinion. Okay? Unless, sabi niya, the seller made such affirmation or statement as an expert and it was relied upon by the buyer. Okay? Take note, General rule, if it's an affirmation of value, it's not an express warranty. If it's a mere seller's opinion, it's not an express warranty. It may become, the seller's opinion may become an express warranty if that seller's opinion is given as an expert and that the buyer relied thereto. Diba? A seller na nagbebenta ng, nagbabuy and sell ng sasakyan for how many years? Say 10 years. By that 10 years, you can say na meron ng expertise yung seller niya. Meaning, he knows what he's talking about. When he talks about the machine, when he talks about the performance of the car, he knows it. Because he is not just a seller anymore, he's an expert. Okay? Hindi lang as an expert, kahit pa naman he gave that opinion as an expert, pwede pa rin naman na hindi mag-rely si buyer doon. So, ang condition, if it's a seller's opinion given as an expert, dapat it must be relied upon by the buyer pa rin. Okay? So, take note of Article 1546, which talks about express warranty. Express warranty is an affirmation of fact or a promise wherein the buyer was induced and later on the buyer relied on that affirmation or promise. Except affirmation of value lang, the price, or given as a seller's opinion. Except na naman, if that seller's opinion is given as an expert and that the buyer relied upon it, then that is an express warranty. Okay? That is Article 1546. Okay, dito, this one I discussed na kasi. Ito, express warranty may include overt words or actions of the seller. Of course, it's the representations made by the seller. And you know, for a fact, in the usual exaggerations in trade na ginagawa nitong mga salesperson, alam naman natin yan, it's common knowledge that these people were trying to sell may sometimes or often or always exaggerate the things that they want you to buy, di ba? Kapag bibili ka, they always seem to be exaggerated, di ba? Because they are trying to sell you something. They are trying to sell you something. Okay? Kapag ganito, they are not in themselves fraudulent. Okay? Why? Because that person is trying to make a living. Okay? And that's normal for someone who is trying to sell. You're trying to convince someone to buy a product. Diba? That's selling. Okay? And exaggerations may come with it. That's a normal tradition or culture in selling. Okay? Kailangan na sabihin mo, nagbebenta ka ng cellphone, Naglalagyan pag ganito na, pag ganyan. Umiinit. Ganun. Siyempre, hindi mo naman, although meron ganun, pero you don't want to highlight those parts when you are making a sale. When you are making a sale, you want to highlight the good parts. Di ba? You're trying to make a sale. Bakit kapag sinabi mo ba yon yung negative na sides, bibili pa ba si customer? Of course, gusto mong i-highlight yung yung qualities ng product. Okay? Pero pwede mo namang sabihin kapag tinanong kung umiinit ba yan. Siyempre malamang pag masyado mong matagal na ginamit at malakas gumamit ng battery at ng yung performance yung cellphone mo, malamang talagang iinit yan. Diba? Even laptops umiinit, diba? Computers umiinit, kaya may mga fans. Diba? That's why normal exaggerations in trade. Okay? Sabi na rin kanina, itong paragraph 3, we have already discussed this one. Okay? A mere expression of opinion, no matter how positively asserted, does not import a warranty. Of course, it's seller's opinion. Unless the seller is an expert and was relied upon. Diba? We've discussed that. Misrepresentation made in good faith is not fraudulent but may constitute error. Okay, meaning, let's say for example, may tinitindang product si seller, ang nakalagay sa product is meron siyang mga ano yun, tawag doon, mga special na mga features, di ba? Mga features. May mga features yung product. Nakalagay doon sa box. Meron din sa manual niya, ganyan. Siyempre, kapag nag-rely dyan si seller, that is in good faith, di ba? Paano kung yung product pala na yun, wala palang ganong features? Okay? Is that fraudulent? No, that does not necessarily mean it's fraudulent as long as the seller merely relied on what the product was supposed to be all about. Kung nandun lahat sa manual, nandun naman sa box, makita mo, and the seller merely relied on that, that is not misrepresentation, that is not fraudulent, but rather that is a misrepresentation made in good faith. Okay? So that is Article 1546, Express Warranty. Okay? So be careful pag nagbebenta kayo, kung ano man ang bebenta niya soon. Okay? Na wag masyadong don't make it to the point na you are selling your product na parang ballooned yung quality niya. Kumbaga sa resume na balloon, ibig sabihin, masyadong maganda yung mga nakalagay dun sa qualities na hindi na totoo. Okay? Bloated. Okay, so just be careful when you're selling because you might not know that that buyer is induced and later on relied on your affirmations or promises. Article 1547, we've talked about implied express warranty. Now we'll talk about implied warranty. Okay? In a contract of sale, unless a contrary intention appears, there is. So in a contract of sale, there is an implied warranty on the part of the seller. Take note. That he has the right to sell the thing at the time when the ownership is to pass, and that the buyer shall from the time have and enjoy legal and peaceful possession of the thing. So, ang appearance parang isa lang, no? But take note, in the first case of an implied warranty, the seller is the right to sell the thing. Of course, di ba? Ba't mo ibibenta yung hindi sa'yo? Di ba? Pero, under the law, di ba? Sabi natin, the seller need not be the owner at the time of perfection of the contract. Di ba? But the seller must be the owner or must have the right to sell the property at the date of delivery. So, dapat kapag magde-deliver ka ng product na nabenta mo, dapat sa'yo na yun or dapat ikaw meron kang right na magbenta nun. Why? Because that is one of your warranties. Diba? Implied warranty. Meaning, even if you cannot find that in the agreement or in the contract, you are liable. Meaning, the seller is liable to the buyer or to any third party if later on si buyer mawalan ng possession dun sa thing. This one kasi is applicable in the sale of land or real property. For example, a seller sells a parcel of land to B. Okay? Ngayon, itong si B, of course, na-deliver na yung property sa kanya. Na-deliver pa yung title sa kanya. Malinis. Malinis. Okay, so, si B na ngayon ang nag-possess dun sa lupa. He possess it because he is the owner. Diba? Later on, after 1 year, there comes Mr. A. Biglang lumitaw si Mr. A. Mr. A instantly filed a case in court. Nag-file siya ng case sa court. Okay? He filed against Mr. B and Mr. S. Ang sabi ni A, ako ang may-ari ng lupang ito. Umalis kayo dyan, sabi niya. Ano nangyari sa kaso? Okay? Si B, napaalis sa lupa. So, ang bagong may-ari na, sabi ng court, ang may-ari niyan si A. Napaalis si B. Okay? Therefore, the seller is liable to the buyer in that case because of implied warranty. Okay? I hope you understand. Because of implied warranty. Why? Because the seller warrants that he has the right to sell the thing at the time of delivery or at the time when the ownership passes. And that the buyer, the seller will guarantee that the buyer will enjoy, tingnan mo to, legal and peaceful possession of the thing. Diba? Legal and peaceful possession, napaalis nga si Mr. B, diba? That's why the seller is liable by virtue of the implied warranty. Okay? Second, an implied warranty that the thing shall be free from any hidden defects or faults or any charge or encumbrance not declared or known to the buyer. Okay? Ibig sabihin, when a seller sells a product, okay, dapat it must be free from hidden faults or defects. Diba? Otherwise, if the buyer will later on find out that that product has many defects or faults, the seller will be liable once again. Okay? Or if malaman ni buyer na naka-mortgage pala yung property, whether real estate mortgage yan, kung real property, or chattel mortgage kung movable, diba? Pag hindi alam ni buyer yan at nagulat na lang siya after, liable na naman si seller. Okay? Take note, these articles shall not be held to render liable a sheriff, auctioneer, mortgagee, pledgee, or other person professing to sell by virtue of authority in fact or law for the sale of a thing in which a third person has a legal or equitable interest. Meaning, ang liable lang sa implied warranty, si seller. Si seller lang ang liable. Okay? Hindi liable yung sheriff. Why? Because the sheriff was only ordered by the court to sell the thing. Diba? If, let's say, for example, there is a judicial sale, the sheriff will just be ordered by the court. And the sheriff will just be doing his part as the sheriff. Or an auctioneer, di ba? Yung nagpapabenta ng public auction. Di ba? They are not the seller naman. Okay? Sila lang yung nag-facilitate ng sale. Or the mortgagee or the pledgee kapag na-foreclose yung property, merong foreclosure sale. They are not the sellers. That's why they are not liable. Ang liable dyan, yung seller mismo, yung may-ari. Okay? That is Article 1547. So we've discussed about 1546 express warranty and 1547 implied warranty. Okay? Ayan. This one, discuss ko na kanina. An obligation imposed by law. Implied warranty is an obligation imposed by law. When there has been no representation or promise. Precisely because implied nga. Especially a warranty arising by operation of law because of the circumstances of a sale rather than by seller's express promise. Okay? The examples of an implied warranty, yung sabi ko, right to sell. Yung the right against eviction, warranty against eviction, or yung sabi natin kanina dito, the right to have and enjoy a legal and peaceful possession. Itong eviction, guys, although define natin mamaya. No, mayroong definition siya mamaya. Warranty against non-apparent burden or servitudes. Mga easements, these are easements. Easements meaning they are burden or servitudes in a property. Let's say, for example, in a property, say for example, yeah, this is property A, this is property B. Okay. Ito, national road or kalsada, road to road. Para maintindihan nyo itong burden of servitudes or easements. CB, hindi siya let's say for example, madami pang property dito. Papansin nyo to sa mga bahay-bahay nyo. Itong si B, kailangan niya ng access sa kalsada. Diba? Kailangan niya makalabas sa kalsada. Pero wala siyang ibang dadaanan kasi nga covered lahat ng property. So, paano ngayon makakalabas sa daanan si B? Okay? Ang ginagawa ng batas, meron tayong easements. Easements. Burden or servitude. Nasaan yung burden? Nasa property ni A. Ibig sabihin, kay A, pwedeng gumawa dito ng, hindi ko na i-discuss yung complexities ng right of way. Okay? Mayroong right of way dyan. Pwedeng maglagay dyan si B ng right of way para makalabas siya sa kalsada. Okay? Pansin nyo, na daanan yung lupa ni A. Portion ng lupa ni A ginawang kalsada. Is that allowed? Yes, that is allowed by law. Kaya siya sinasabi na burden. Burden yan sa property ni A. Kasi, imbes na yan yung buo yung lupa niya, nabawasan. Because he needs to give way to the lot sa likod. Okay. Di ba unfair yan? Eh, paano kung walang ganyan? Paano lalabas yung taon sa loob dito? Saan siya dadaan? Kung ayaw mo siyang padaanan sa lupa ni A, saan siya dadaan? Diba? That is the logic of the right of way. Yeah. Madaming nag-aaway dahil dyan sa right of way. Alam ko, madami kayong alam dyan. Baka may experience din kayo dyan. Okay? Warranty against hidden defects, as I have said kanina. Warranty against redhibitory defects on animals. Parang hidden defects din yan. Kaso lang sa animals. Okay? Yung mga may mga sakit. Okay? Although a seller is bound by implied warranties in law, nevertheless, an agent of the seller may bind himself to such warranties by express contract stipulation. Meaning, the agent of the seller may be liable for implied warranty not because of the existing implied warranty as provided by law, but because of express stipulation. Because of expressly stipulated provisions in the contract. Okay? Now, we've discussed express warranty and implied warranty under the Civil Code. Now we'll discuss warranties under the Consumer Act of the Philippines. These two laws apply in harmony. So when we talk about express warranty as provided by the Consumer Act of the Philippines, we also talk about it in the Civil Code. So ang sabi niya, merong mga bagong provisions with regards to express warranty. So una, yung terms of express warranty. The terms must be clear and understandable. Of course, it must be clear and understandable because under an express warranty, there may rise an obligation. Pag may obligation, kapag hindi nagawa, pwedeng kasuhan. That's why it must be clear and understandable para alam mo kung ano yung obligation mo. Must not be vague. Dapat hindi malabo. Malinaw. Kasing linaw ng relasyon yung dalawa. Okay. Number 2, identify the parties involved. Of course, you have the seller and the buyer or the manufacturer, kung kasali or si producer. Okay? Third, state the products or parts covered. Diba? Not all of the products or the parts ng product is covered by a warranty. There are parts wherein that part will really deteriorate through time because of wear and tear. Dahil sa paggamit, talagang masisira sa paggamit. Yung normal na paggamit na hindi pag-abuso. Normal na paggamit. Talagang madudumihan, talagang magasgasan. Kasi nga, ganun yung use niya. Okay, kaya most of those products are not warranted. Hindi lahat. Like sa sasakyan, hindi lahat yan warranted. Okay. State what the warrantor will do. What the warrantor will do in case of breach or in case of application for warranty, and whose expense in such cases of defect or malfunction, whether it be the seller or the manufacturer. Okay? State how consumer must do to avail the warranty. Of course, dapat dun sa express warranty mo, nandun kung paano i-claim nung buyer yung warranty. If later on, for example, nasira kaagad yung product, di ba? Kapag bumibili kayo ng TV, for example, may warranty yan, sir, for 7 days. Kapag nasira or biglang hindi gumana, pwede nating palitan. Okay, ganun yun. And stipulate the period of the warranty. Of course, warranties have periods. Diba? Sabi ko kanina, 7 days. Yung iba, 1 month, 6 months, 2 years, 5 years. Ayan. Depende dun sa warranty. Kaya kailangan clear siya. Lahat na nandun, makita mo na. Para wala ka lang tatanungin. Para kapag later on, may nangyari sa product without your fault, you can avail of the warranty, alam mong gagawin mo because nandun na. Either merong warranty card or merong mga warranty manual, nandun na. Okay? That is not because of the Civil Code but because of Consumer Act of the Philippines. Now, express warranty is operative from the moment of sale. So from the moment that the sale is perfected, there's an express warranty. Okay? And by making that sale, you need to have a sales report. Okay? Which means that all sales made by distributors of products shall be reported to the manufacturer, producer, or importer within 30 days from the date of purchase, unless otherwise agreed upon. Meaning, you do this because you need to inform the manufacturer, the producer, or the importer that you have already sold the product at this date. Diba? Para kapag nagkasira, later on, sila din naman kasi yung manonotify. Okay? Para alam nila na kung paano i-treat yung circumstance or yung situation. Okay? Failure to make or send report, failure of the distributor to make the report shall relieve the latter of its liability under the warranty. Okay? If you fail to make the report, you'll be relieved of its liability under the warranty. Okay? The retailer shall be subsidiarily liable in case of failure of both the manufacturer and distributor to honor the warranty. Di ba? Sabi dito, the retailer is subsidiarily liable. Meaning, ang primary liable person daw sila manufacturer, producer, distributor. Okay, they are primarily liable. Ibig sabihin, with regards to damages or a payment in availing express warranty, primarily liable tong mga taong to. Sila yung talagang liable na parties. Okay? Kapag hindi sila nakabayad, pwede mong habulin si retailer. They are subsidiarily liable. Take note, hindi mo kaagad pwedeng habulin si retailer. Hindi ganun. Dapat ito muna ang habulin mo, yung manufacturer, producer, or distributor. After them, kung wala talaga, pwede mo nang habulin si retailer. Okay? Enforcement of warranty. The warranty right may be enforced by a mere claim. You need only to present to the immediate seller, yung sabi ko niya, the warranty card. The warranty card or the official receipt. Diba? Diba kapag bumibili kayo ng product or ng equipment or ng furniture or ng appliance, yan. Pwedeng may warranty card yan eh, di ba? Or kung walang warranty card, sasabihin sa'yo ng salesperson, ma'am, patago na lang po ng resibo para kapag mag-claim kayo ng warranty, di ba? Para po magamit natin pag nag-claim kayo ng warranty. Ayan, yung either warranty card or official receipt. Of course, record of purchases must also be kept, and contrary stipulations are null and void. Okay, are null and void. Meaning that stipulations must coincide with the Consumer Act of the Philippines. Okay, designation of warranties shall be clear and conspicuous, meaning there could be a full warranty or limited warranty. When you are able to meet the minimum requirements, you can avail of the full warranty. If you are not able to meet the minimum requirements, then you're only entitled for a limited warranty. Okay? The duration of warranty, the seller and consumer may stipulate the period within which the express warranty, of course, shall be enforceable. Parang dun sa unang kanina, we talk about we can stipulate the period of warranty. The period is the duration of the warranty. Meaning, if sabi niya 5 years ang warranty mo, of course, from the date of sale, okay, may 5 years ka to avail of the warranty. Okay? Of course, when you want to claim through a warranty, hindi naman kaagad yan. Siyempre, i-verify nila lahat din yung claim mo para ma-prove kung totoo ba, kung pwede ba na i-honor ba yung warranty. Okay? Breach of warranties. Breach of express warranty, the consumer may elect to have the goods repaired or its purchase price refunded by the warrantor. Okay, take note ha. If it's an express warranty, the consumer or the buyer may elect to repair, right? Uh, uh, to, to repair or to return the purchase price. To have it repair or return the purchase price. Kung implied warranty naman, the consumer or the buyer may retain the goods and recover damages or reject the goods plus the purchase price plus damages. Okay? So yan yung difference ng express sa implied warranty. One of the difference. Meaning, in a breach of express warranty, the buyer may opt to repair the appliance or the product or the goods or to recover the purchase price or to refund the purchase price. Sa breach of implied warranty naman, mas mabigat kasi you can retain the goods pero may damages. You can reject the goods, meaning ibalik mo, pero kukunin mo of course yung purchase price plus damages. Itong damages na yan, these are monetary considerations, di ba? Money yan, monetary considerations. Hindi yan damage na damage. Damages lang ang tawag dyan. Meaning, damages kasi nga, let's say for example, you're driving your newly bought vehicle and biglang suddenly, bago lang, one day lang, sabihin mo, kakalabas mo lang sa kasa, biglang nag-malfunction yung engine, nag-stop, pababa ka pa naman sa isang hilly na road. You nearly died. You suffered damages. Paanong damages? You suffered mental and emotional damages because of that experience. Yan, pwede mong ma-recover. Meaning, you cannot compensate what you have felt or what you have gone through because of that experience. That's why you are asking for compensation, monetary compensation. That is what is damages in court. Kaya nga, yung mga umutang, di ba? Kapag ay nako. Yung mga umutang kapag yung mga umutang, imbes na yung utang lang sana ang babayaran nila. Okay, imbes na utang lang sana ang babayaran nila. Because of their delay, meron pang interest. Okay? And the creditor can also ask for damages. Kasi na-late na eh. Okay, na-late na yung payment. Okay, para hindi yan maulit, I may ask for exemplary damages. Exemplary damages meaning parang sample. Sample sa iba para hindi na magaya, para hindi na maulit yung ganyan. Yan. Bayad lahat yan, monetary considerations. Article 1548, yun na yung eviction. We talk about eviction. Warranty in case of eviction. Eviction shall take place whenever by a final judgment based on a right prior to a sale or an act imputable to the vendor, the vendee is deprived of the whole or part of the thing purchased. Meaning, there is eviction when there is a final judgment. Take note. There is a right existing prior to the sale or an act imputable to the vendor. There is a deprivation of the whole or part of the thing purchased. Okay? Meaning, just like what I've said kanina, the seller sold the parcel of land to be, diba? B later on occupied this property. He possessed this property because he is now the owner. Then after 6 months or 1 year, here comes Mr. A. Mr. A filed the case in court alleging against Mr. B and Mr. S, saying that I am the owner of this property. Okay? So what happens? The court evicted Mr. B. So, ang bagong may-ari is si Mr. A. Therefore, Mr. B is evicted. Parang sa PBB, eviction. Napaalis siya. Ganon ka magpaalis ng tao sa lupa. Hindi yung by versa. Hindi tututukan mo ng baril, sabi mo, umalis ka dyan, lupa ko yan, minura mo at lahat. Hindi ganun ang magpaalis ng tao. Let's say, for example, given that you have the title to that property and somebody squat there, somebody built a house, or somebody stayed there, occupied your property, you don't go there and enforce your right like that. Because under the law, the person who is currently occupying the land is presumed to be the owner. Therefore, if you want to evict that person or if you want to oust that person from your alleged property, okay, then that's the time that you file your case in court. Kapag ginawa mo kasi yan, ikaw pa ang pwedeng makasuhan. Pag pinaalis mo ng puwersahan, kinalagkad mo, binakbak mo yung bahay, nang walang order ng court, ikaw pa ang kakasuhan. Mapapabayad ka pa. That's why you can only evict a person through legal means. Eviction. Yan yung eviction na tinatawag natin. Okay? The vendor shall answer for the eviction even though nothing has been said in the contract. Why? Because warranty in case of eviction is an implied warranty. Okay? The contracting parties may increase, diminish, or suppress this legal obligation of the vendor. Meaning, let's say for example, lipat-lipat na. Let's say for example, in yung warranty, the total worth is 10,000 yung product. Sinabi mo na in case na you are evicted, okay, I'll pay you 90% of the price. Or I'll pay you 80% of the price. Diba? Pwedeng ganun. You can increase it, you can diminish or suppress. But I want you to take a look at, itong sabi natin na, based on the right prior to the sale or an act imputable to the vendor. Meaning, that for example, a sale was made here at this timeline. Let's say, for example, today itong araw na to. Sale was made today. If the right exists prior to the sale, then the seller is liable. Okay? If the right exists prior to the sale. But if the right is completed or only existed after the sale, then the seller is not anymore liable. Take note of that, take note. Kapag before ng sale, seller may be liable. Kapag after, the seller may no longer be liable. Okay? Requisites of eviction. So what I've said kanina, final judgment. There is deprivation. The right exists prior to the sale or an act imputable to the vendor, and that the vendor has summoned and made co-defendant the suit for eviction in the instance of the vendor. Meaning, ang kinasuhan si vendi tsaka si vendor. Okay? The vendor is made co-defendant in the suit for eviction at the instance of the vendor. Eviction is the act or process of legally dispossessing a person of land or rental property. Diba? Just like what I said kanina. Okay? Kung rental property naman, para makarelate kayo, if there are some of you here na nandito na sa Tagigaraw, okay? Let's say, for example, you are renting renting either a boarding house. Of course, kung medyo may kaya ka, medyo burgis ka or mayaman ka, apartment. Okay? Boarding house or apartment. Okay? Di ba? Nagrerenta ka dyan. Nagbabayad ka ng monthly payment. Okay? Rental payment. Okay? At meron kayong duration. Say for example, 1 year. Or habang nag-aaral ka, bayad ka ng 2,000, 5,000, 3,000 per month. Okay? If, let's say for example, 1 month, 2 months, 3 months ka nang hindi nakakapagbayad, or nag-expire na yung term ng renta mo, or dinotify ka ni lessor mo na i-close ko na yung property. Kailangan mo na umalis. You can be evicted. Pwede ka mapaalis. Diba? Of course, gaya nung sabi ko rin kanina, hindi basta-basta. Hindi porket umuupa ka lang sa boarding house or sa apartment na yan, biglang papasukin ng kwarto mo or yung apartment mo at tapon lahat ng gamit mo. Hindi pwede yun. Granting that you have not paid, granting that you have expired na yung agreement nyo, that is still not proper. Okay, the proper way is to, first, of course, you talk to each other, di ba? You try to do it outside court. Pero kung hindi pwede, you can do it through court, through legal means. Hindi pwede yung karakaraka just because you have a right, you exercise it, at the disadvantage of another person. Take note, for those of you who are eyeing to be lawyers or who want to be to later on become a lawyer, hindi tayo legalist. You can choose to be legalist. Okay, but it's better if we provide justice. Okay. And justice is not equal with the law. Because there are laws that are not just. I know you agree with me on that part. There are laws that are not just. And sometimes in achieving justice, we may need not to apply the law. Because sometimes applying the law is not to the advantage of the many. For example, yung mga meron ng advanced knowledge dyan, you hear the word or you hear the phrase, ano tawag doon? The law may be harsh. Di ba? Sabi nila, the law may be harsh, but it is still the law. Meaning, kahit pa ganyan ka-harsh or kalupit ang batas yan. Kailangan mo yung i-apply. That is true. I agree with you 100% on that. Okay? But you cannot achieve justice there. Okay? Towards now, ngayon, during our era, we don't lean towards legalism. We lean towards social justice. Okay? That's why we don't want rigorous application of the law to the point na we don't consider the rights of another person. Bakit? Kung ikaw ba yung nasa kalagayan ng isang tao, you would want that the law may be strictly applied to you. Siyempre, ikaw, hingi ka rin ng, gusto mo rin na light yung application ng law, gusto mo rin na maging considerate yung mga tao, di ba? And that's justice, that's social justice. Okay, that's why, pag napalayas kayo, usap mo na. Hindi yung ipapatapon yung mga gamit, lahat. Tanggalin kayo, kakalagkarin kayo sa boarding house or apartment. So, hindi ganun. Article 1549, the vendee need not appeal from the decision in order that the vendor may become liable for eviction. As long as there is final judgment and that the decision is final, that is already considered as an eviction and the vendor is now liable. Article 1550, when adverse possession had been commenced before the sale, but the prescriptive period is completed after the transfer, the vendor shall not be liable. Okay, let's discuss. First, what is okay? First, what is adverse possession? Adverse possession or open, continuous, and free possession of a property. Okay? Or an inalienable or disposable property. Okay? Meaning, let's say for example, merong alienable and disposable property na hindi siya nakatitle. There is no title. But it is already alienable and disposable. And you possess it. That could be adverse possession. Okay? Adverse possession could be in good faith and in bad faith. When we say that adverse possession is in good faith, the prescriptive period is 10 years. When we say that adverse possession is in bad faith, the prescription is 30 years. So how do we do this? There are cases wherein these alienable and disposable properties have already been occupied by another person. Let's say, for example, Mr. B is the known owner of this property. But Mr. A, kasi nga, si Mr. B, let's say, for example, is an OFW, nasa abroad. He occupied this property. Now, if Mr. A has knowledge or knew that this property was really was originally from Mr. B, then his adverse possession is 30 years, meaning his right will only be fully established after 30 years. Imagine, because you're in bad faith. But if Mr. A has no knowledge of this, that the property was owned by Mr. B, then that is adverse possession in good faith. Therefore, you will have a right to that property after 10 years. Matagal pa rin. Why? Because it is an adverse possession. Okay? I hope that's clear. With regards to paano lupa namin, sir? If your land has already a title, whether it says there original certificate of title or transfer certificate of title or yung mga emancipation patent, okay, those are titles. Meaning, once you have them in your favor, hindi na pwede ang adverse possession. So when does adverse possession apply? Only kapag kapag yung title, kapag yung land is not titled and the land is alienable and disposable. Okay? So that is adverse possession. Meaning, this one, you can apply yung timeline na ginawa ko kanina. Sale. If the sale is made here, granting that this bar is today. If the right or the adverse possession is completed before the sale, then the seller is liable. Diba? But if the adverse possession is completed after the sale or the transfer, then the seller is no longer liable according to Article 1550. Okay? I hope that's clear. Article 1551. If the property is sold for non-payment of taxes due and not made known to the vendee before the sale, the vendor is liable for eviction. Okay, take note ha. Ito naman, same example tayo. Seller sold now the property to the buyer. This is a piece of land. Take note, if you own a property in the Philippines, you pay taxes. If you own a real property in the Philippines, just like a land, a parcel of land, you pay what we call a real property tax. Now, if you fail to pay real property tax to the point that you become a delinquent, this property may be sold. Pwede itong ibenta. Who will sell this? The government may sell this. For what? The government will sell this in order for you to pay your real property tax. Wala kang makuha dyan. There are instances wherein the seller is aware that that property may already be subjected to delinquency sale by the BIR. Okay? And bago pa mangyari yung sale niya, binibenta nila yan. Okay? Bibenta nila yan kay B. Okay? Para hindi sila maging liable dun sa real property tax. Siyempre, si B naman, gustong-gusto ko kasi part ng bibilin ko is babayaran ko yung real property tax. May mga ganong scenario. But, if later on, si B, hindi siya aware, he is not aware, he has no knowledge that there is non-payment of taxes by the seller, and later on, B is evicted, napaalis si B dun sa property. Hindi niya alam na delinquent si seller. The seller is liable for eviction. Okay? That is Article 1551. Okay? Article 1552, the judgment debtor is also responsible for the eviction in judicial sales unless it is otherwise decreed in the judgment. Meaning, in a judicial sale, di ba? Sino ang may-ari niyan? Si judgment debtor. Why? Because originally, si creditor may pinautang kay debtor. Ngayon itong debtor, hindi na siya makabayad. Kinasuhan ni creditor si debtor and therefore, nag-order ang court na magbenta ng properties ni D para mabayaran. So that's a judicial sale. That even though ang nag-facilitate ng bentahan could be the court, the sheriff. Okay? Si debtor or si judgment debtor is still liable kapag yung bumili dun sa judicial sale is evicted. He is liable. Okay? So parang siya pa rin yung owner. Siya naman talaga yung owner. Okay? Let's say for example, meron siyang lupa. Not knowing na yung lupa na pala na yan, meron pang ibang claimants. Later, na-evict si B. Okay? Liable ngayon si debtor or si judgment debtor. Okay? That's Article 1552. Article 1553, any stipulation exempting the vendor from the obligation to answer for eviction shall be void if he acted in bad faith. Let's read that again. Any stipulation exempting the vendor from obligation to answer eviction shall be void if he acted in bad faith. Therefore, it's safe to say that a stipulation, yan yung agreement sa contract. A stipulation in the contract exempting the vendor from obligation in case of eviction may be valid. Why? It is valid if the vendor is in good faith. But it is void if the vendor acted in bad faith. Okay? Why? Di ba? Let's say for example, si vendor nagpalagay sa contract ng stipulation na ma-exempt ako in case na ma-oust ka sa possession mo sa ownership buyer. Okay? Wala na akong kasalanan dyan. Okay? If talagang walang alam si vendor doon, then that is in good faith. Then that stipulation or that agreement is valid. Okay? But if ni-request yan ni vendor, kasi nga may aware siya na later on, nga pala, may nagki-claim pala sa lupa na yan. Aware siya, may knowledge siya na may claimants at mayroong pabalak mag-file ng case sa kanya, binenta niya yan at pinalagay niya sa contract na wala na akong kasalanan pag na-evict ka dyan. Labas na ako dyan. That statement or that stipulation is void. Why? Because the vendor is in bad faith. Okay, as simple as that. Stipulation waiving obligation to answer for eviction. The buyer can waive the obligation of the vendor to answer for eviction. However, the said stipulation becomes void if the vendor acted. Of course, that is Article 1553. If the vendee has announced the right, hanggang Article 1555 lang tayo, okay? If the vendee has announced the right to warranty, in case of eviction, the eviction should take place. The vendor shall only pay the value which the thing sold had at the time of the eviction. Meaning, the vendee can renounce his right to warranty. Okay, in case of eviction. Let's say, for example, the vendee originally in the contract, merong nakalagay doon, merong warranty against eviction. If later on pinatanggal yan ni vendee, hindi, okay lang, kahit na wala yung warranty na yan, okay lang. Okay? And na-evict siya. Okay? The vendor is liable to pay for the value of the thing. Okay? The vendor is liable for the value of the thing. Should the vendee have made the waiver with the knowledge of the risk of eviction and assume its consequences, the vendor shall not be liable. But, sabi niya, if merong originally na warranty against eviction dun sa contract at pinatanggal na naman ni vendee or ni buyer. Okay? Pero this time, the buyer, alam niya na merong risk of eviction or alam niya na merong mga nag-claim dun sa property or alam niya na may issue yung property. And later on, na-evict si buyer, at that time, hindi na liable si seller. Is no longer liable. Why? Because of bad faith. Okay? Meaning, the vendee or the buyer already has knowledge na pwedeng pwede siyang ma-evict. But still, winave niya. Ni-renounce niya yung right to warranty niya with knowledge. Okay? At that time, the vendor is no longer liable. But if we go back to the first case, if ni-renounce niya yung right to warranty niya, not because may alam siya, but because tiwala naman siya sa buyer. Tsaka wala siyang knowledge na may risk yun. Nasa kay buyer talaga, ay kay seller talaga yung property na yun. Then in that case, kapag na-evict siya later on, kahit pa winave niya yung right niya na yun, pwede pa rin siya mag-claim ng warranty, but only up to the value of the thing. Okay? That is Article 1554. Okay? If the vendee has no knowledge of the risk, the vendee may claim only up to the value of the thing. If the vendee has knowledge of the risk of eviction and later on na-evict siya, he can no longer held liable the vendor. Okay? That is the two kinds of waiver consciente and waiver intentionada. Okay? Waiver consciente is the first instance wherein the vendor shall only pay the value. Okay? But waiver intentionada, meaning even with knowledge, you intentionally renounce your right to warranty, then the vendor shall no longer be liable. Okay? Now, the last article, before I will let you go. When the warranty has been agreed upon or nothing has been stipulated at this point, whether, ang sabi dito, yung sa first phrase na binasa ko, yan, whether express warranty daw or implied warranty, ito ang pwede mong ma-recover in case of eviction. What can you recover in case of eviction? What can you recover or what can you demand? We can demand, of course, the value of the things sold at the time of eviction. Take note, the value at the time of eviction, hindi at the time of the sale. Let's say, for example, like kotse, sasakyan, binili mo ng 5 million, let's say, for example. Okay? After 6 months, na-evict ka, natanggal ng sasakyan, nawala sa'yo yung sasakyan because of someone claimed it, for example, you can recover the value of the car. Not yung 5 million na binayaran mo, but value at the time of eviction. If na-evict siya ngayon, yung value niya ngayon. And knowing yung mga sasakyan, nagde-depreciate, so hindi na 5 million ang ma-recover mo. Okay? So yun yung una, value. Second, the income or fruits, of course. If, however, if this has been ordered by the court. Okay? So, in case of lupa, if later on, kung sana hindi nawala sa iyo yung property na yan, meron ka sanang na-generate na income or fruits, yan, pwede yan. Okay? Pwedeng i-recover mo yan. So, maging liable ang vendor dyan. The cost of the suit. Okay? The cost of the suit which caused the eviction, di ba? Kapag kinasuhan ka and you need to defend yourself, pwede mong ilipat yung gastos kay vendor. Why? Because you need to defend yourself, therefore, ikaw magbayad ng attorney's fees ko. Okay, the cost of the suit may be paid by the vendor. The expenses of the contract, okay, if the vendor, of course, has paid for them. Let's say, for example, yung notarial fee, yung binayaran mo sa BIR, sa ROD, lahat para may process yung contract of sale, ikaw gumastos na buyer. Kapag na-evict ka, pwede mong singilin si vendor. Okay, expenses. And last but not the least, damages and interest, of course, and ornamental expenses if the sale was made in bad faith. Of course, granting that this will involve the return of the value of the thing, merong interest. Meron ding damages because there could exist bad faith on the part of the seller. Why? Because there is breach of warranty or uh, there is an existing knowledge on the part of the seller. So, in case of express warranty or implied warranty, if the buyer is evicted, the buyer may recover from the vendor the value of the thing, income or fruits, cost of suit, expenses by the buyer, and damages, interest, and ornamental expenses or vice. Okay? So, I leave you with that. We'll continue next meeting with our discussion. May question? If you don't have any question, I'll end this class, okay? Okay, sige. Goodbye. Goodbye, everyone.
Bye po. Thank you, sir.
Thank you po,
Bye
sir.
po, sir.
Bye po, sir. Thank you po,
Bye, sir.
sir.
Thank you po.
Thank you po.
Thank you, sir.